I head over to New Mexico right now. I'm bringing you the latest in the upcoming Rust shooting trial against actor Alec Baldwin. On Friday, a judge denied Baldwin's latest attempt to have an indictment on involuntary manslaughter dismissed, meaning the trial is scheduled to begin in just 1 week. Baldwin's attorneys requested that the judge toss the indictment due to the firearm that killed cinematographer Halyna Hutchins being damaged during forensic testing at an FBI lab. Defense attorney John Bash argued in a motion hearing last week that the prosecution's destruction of the firearm deprived the defense of a chance to examine it in its original state and affecting their ability to form a proper defense. The prosecution, however, argued to the contrary, and in Friday's written ruling, Judge Mary Marlowe Summer denied the dismissal of the indictment and said that the defense did not offer evidence beyond speculation that an unadulterated gun could have exonerated Baldwin. To catch you up on the case, Baldwin faces up to 18 months in prison if convicted of involuntary manslaughter after the prop revolver he was holding discharged a live round, fatally striking cinematographer Halyna Hutchins during a rehearsal in October 2021. Baldwin claims he did not pull the trigger when the gun fired. Let's take a look back now at arguments made by both sides in Monday's hearing, and we'll break it down for you on the other side and its twisty procedural history of charging, dismissal, charging, dismissal, charging. I don't even know where we're at right now.
A single reason why they did not disassemble the firearm and take pictures of the internal components, knowing the risk that they would be destroyed. They haven't come up with anything. We'll talk a little bit about their argument about standard operating protocol, because that's a complete red herring. But there is no substantive reason why they didn't do that. If you look at the pretrial interview of Michael Hague, it's quoted there on the left, although our font is starting to get really small here. They say they always disassemble the firearm first. So, I mean, they know what they're doing, and they always disassemble it first. If you look on the right, this is from Friday with Corporal Hancock. You did not ask the FBI to disassemble the firearm to take pictures of it. Do you? I think it probably means did you? I don't know their process or how they run their testing, so I don't believe it was specifically requested from us. And she didn't ask to videotape it either. It's not about the FBI's process. It's about an investigation by New Mexico law enforcement and New Mexico prosecutors that is there to both find the truth and to protect the rights of the defendant. And they didn't do that. They didn't think about it. They knew it would be destroyed, and they did nothing to preserve the evidence for the defendant.
What's important there is that Mr. Hague in that report did not say there were modifications to this gun. What he said, there were irregular off-axis diagonal tool marks of an unknown origin. It seems unlikely, although it cannot be excluded, that these tool marks were made by the FBI's testing. So he doesn't say the FBI testing didn't create these. He clarifies that after he has an opportunity to speak and interview Mr. Ziegler about how he conducted that test. That does not equate, Your Honor, to bad faith at all whatsoever. That's a red herring that the defense is bringing before this court. The bottom line is that under Youngblood, under Trombetta, they fail. Under Youngblood, they fail. They cannot demonstrate bad faith, because what is really important here is, what did law enforcement know? Law enforcement knew that they received no requests from Mr. Baldwin, from his attorneys. Hey, can we look at this gun? There may have been something mechanically wrong with this gun. There was modification to this gun, was a fortuitous defense that the defense developed after the gun was damaged, or not the gun, but the internal components of the gun were damaged by the FBI testing. You have a witness who in a pretrial interview stated that he saw Mr. Baldwin pull the trigger. That's Zach Sneesby. Mr. Baldwin's own statements that the gun was working fine.
All right, Mike, let's break down this judge's ruling right now. I mean, what you hear here, so our audience understands, is that there's been a modification, a change. The defense is going to be deprived of an opportunity to be able to evaluate it, but she's arguing bad faith. Bad faith is one of the factors that goes into what a judge is going to do in these circumstances. But I don't think the defense has to run around saying, keep the gun in its pristine position. They should have an opportunity to examine the evidence and make a determination, especially since there's been allegations here that when the gun was being fired at one point, it fell apart. It's sloppy again.
It's almost unbelievable, because part of her argument is there really isn't a timeline to review evidence where they're saying, oh, you didn't review it back then. Well, there wasn't these problems with the evidence back then. We've just become aware that, that there may have been some destruction of what you're trying to use as proof against a defendant who has a presumption of innocence, and now you're saying we can't look at it or it's irrelevant. I just don't understand that, and I think that really should weigh heavily on whether or not that forensic expert is in fact admissible, since the fact that nobody from the defense had a chance to challenge it and all this destruction happened before the defense was able to look at it.
Yeah, we'll see if we get a little clarity, because while the judge may not have precluded the government from using it, it'll be interesting to see if the judge allows the defense to bring that out to the jury so that they could at least determine the credibility that they were precluded from being able to do an evaluation, and it may go towards the credibility, not the admissibility of the evidence. Pretty heavy, Mike. We're in pretty heavy territory here. We're talking about admissibility and weight of the evidence. Baldwin's defense in this case is that he did not pull or depress the trigger when the live round was fired. Is this actually a possibility? Can you walk us through by what means that you could load and discharge this kind of weapon, 45 caliber, for our audience at all? Does this make any sense? And I know that you're not a firearms expert, Lateef, but does this make any kind of sense to you that this is something that would be viable? Because I believed there may be evidence where he had indicated he had pulled the trigger, or maybe I'm wrong about that, but what do you think?
Well, it could be a viable defense. We hear about firearms accidentally discharging all the time. And I think that was the whole point of the motion to dismiss, was that we'll never know if this gun malfunctioned because the FBI destroyed it. And so that was the reason why they filed the motion, because they're not allowed, or they don't have the ability now to test this gun to see if it was prone to accidental discharge. So I thought it was a good motion. It was a motion I would have made, but it was ultimately denied.
Okay, now latest news, Mike, is that Baldwin is also facing financial troubles, paying out a confidential amount that he owes to the family of Halyna Hutchins in a civil settlement. And an attorney for her husband, Matthew Hutchins, says they're considering suing Baldwin for breach of agreement. How does the costly lawsuit affect Baldwin, and can we anticipate that these hefty legal bills and fees that he has will affect his career or his ability to be able to defend himself in the criminal case even?
Well, it's an interesting question about whether or not it will affect his ability, because if he's really going through financial difficulties and it shows that he's now broke, then he may qualify for a public defender or something of that nature. So he's entitled to effective assistance of counsel. Just because you pay a lot doesn't mean that the counsel is any more effective, because we all know many public defenders who are very, very good at what they do because of the fact they're doing it all the time. So I don't really see that being much of an issue. And quite frankly, I don't know if it really helps him to highlight that from the defense perspective, because the jury's going to wonder, if they start talking about his financial difficulties and the jury hears about it, it almost seems like if he's paying that, it's almost an admission that he feels he's responsible for the lawsuit, even though civil and criminal have two different standards of proof.
Yeah, we haven't even gotten into any of this, but people ask this question all the time. Do high-profile people and famous people, they get a break, whatever? The guy's not getting a break. He's been in and out of having a case dismissed, not dismissed, prosecutors that were not eligible to be prosecutors on the case, up, down, and all around. And now he's got a high profile. They're watching it. Prosecutors are not going to let go. Now he's got financial troubles with a civil suit. It's very, very difficult to represent somebody that's a high-profile person like this when pretty much everyone's got their guns out for him, no pun intended. Anyway, we're going to take a quick break. Lori Vallow-Daybell is up next. Please stay with us.